Now in session, the Honorable Kelly Mark Easton presiding. God save this Commonwealth and this honorable court.
Please be seated. We have the all clear to begin. We are here today for the trial in the matter of the Commonwealth of Kentucky versus Dusty Lawrence. My name is Judge Kelly Easton. I'd like to remind all of the competitors today, including the timekeepers, that you may not use cell phones for any reason during this round. And you may not communicate with anyone other than your competing teammates during the round. Spectators, please remember this includes you. Students may not communicate with you until the round is over and ballots have been accepted by the tab room. But also like to make sure that everyone makes sure that their cell phones and any other electronic device, anything that may make noise, are turned off or on silent. If you need to leave the courtroom during this round for any reason, please make sure you do so quietly and, if possible, at the end of a witness's testimony or at some other break of time in the trial. Also, we've been informed that those who are participating may use bottled water during the trial. However, no one in the gallery may have anything to drink or eat, including water, in the gallery during this round. At that point then, let me ask counsel, are there any matters we need to take up before the opening statements?
Yes, Your Honor. Before we do that, maybe proceed with introductions. Good morning, Your Honor. My name is Ben Allison, and alongside me are my co-counsel.
Good morning, Your Honor. My name is Emma Combs, and I will be giving the opening statement in today's case.
Good morning, Your Honor. My name is Mia Duggins, and today I'll be conducting the closing argument. And our three witnesses.
Good morning, Your Honor. My name is Claire Donaldson, but today I'm Detective Valerie Oldham.
Good morning, Your Honor. My name is Emily Murphy, but today I'm Julie Calloway.
Good morning, Your Honor. My name is Andrew Thompson, but today I'm Vicki Logan.
Together we represent the Commonwealth of Kentucky.
Thank you.
Your Honor, I have one pre-trial matter at this time. I would like to point out that mock trial rules are different than the real world. Under Rule 4.p of mock trial rules, we do not sequester witnesses. In other words, all witnesses here today are present to see other witnesses testify. With that, the Commonwealth is ready to proceed.
Thank you, sir. And for the defense.
Yes, Your Honor. May we make introductions for the court? Good morning. My name is Sydney Herring-Shaw. I will be performing the direct examination of Cole Perry and the cross-examination of Jody Calloway. And I'm here with my co-counsel.
Good morning, Your Honor. My name is Karen Harper. I'll be conducting the direct examination of Shay Davis, the cross-examination of Vicki Logan, and I'll also be giving the opening statements for the defense.
Good morning, Your Honor. My name is Mallory Jones, and I will be conducting the direct examination of Dusty Lawrence, the cross-examination of Val Oldham, as well as delivering our closing statements.
May our witnesses introduce themselves?
Good morning, Your Honor. My name is Silas Kugel, and today I will be portraying Cole Perry.
Good morning, Your Honor. My name is Bailey King, and today I will be portraying the role of Shay Davis.
Good morning, Your Honor. My name is Zach Ross, and today I'll be portraying the role of Dusty Lawrence.
Your Honor, we do have a few pre-trial matters we'd like to attend to. First, may we have permission to move freely around the well of the courtroom?
Any objection?
No, Your Honor.
All counsel may move freely around the well.
Thank you. We also want to ask if you would like us to move to strike or to assume that our record has already been stricken.
Response?
No objection, Your Honor.
You may proceed as you choose. You may move strike.
Thank you. We also would like to bring the court's attention to Special Instruction 8A1. This states that both Cole Perry and Val Oldham possess the educational and professional background to give their opinions regarding fire investigations.
Any objection or response?
No response at this time.
Yes, one more thing. We would also like to bring the court's attention to Special Instruction 8A3, which states that the court believes there is sufficient overlap to allow Cole Perry to offer opinions on the sufficiency of Detective Oldham's fire investigation and their conclusions.
Objection or response?
No, Your Honor.
And with that, the defense is ready to proceed.
Thank you. Then, at this time, with the prosecution.
Thank you, Your Honor. May it please the court, opposing counsel, members of the jury. Whoops! I didn't mean to do that. I said whoops, and I'm telling you now that it was in no way intentional. Isn't that enough? No, it is not enough. Because every action I took clearly showed that I intended to do that. Why? Because I did it intentionally. But I want you to think that I did it or accidentally. You could say I did it accidentally on purpose. It was intentional. That is what this case is about today. A case that at its heart is about deception. It involves a defendant intentionally setting fire to a home while trying to make it look like an accident. But he did a terrible job. So every time the defendant comes up to that stand today and says that this was, whoops, an accident, you'll say, no, accidentally on purpose, it was intentional. My name is Emma Combs, and along with my fellow prosecutors, we represent the Commonwealth of Kentucky in today's case. We have the burden of proof beyond a reasonable doubt that the defendant, Dusty Lawrence, intentionally set fire to a large historic home that he inherited and could no longer afford to keep. This was all a ploy to recover up to $1 million from an insurance policy. Now let me take a step back, and I'll tell you how we got here. In early 2022, the defendant inherited a large historic home here in town called the Caslin House. Now this was trouble for the defendant. He was frequently unemployed, living in a small apartment, and had no way to afford this house. So he decided to sell it. The catch is, no one would buy it. His house sat empty for months with a for sale sign in the yard. It was in rough shape and it needed a lot of work. And when the defendant realized that he wasn't going to be able to sell it for his asking price, he remembered his insurance policy. So on the night of February 14th, 2023, the Caslin House was engulfed in flames, leading us to today's proceedings. Now, like I said at the beginning, the defense is going to try to make this case all about an accident, spontaneous combustion of wood stain that the defendant just so happened to leave lying around. But every other piece of evidence will show that this was intentional. Now, the first witness you're going to hear from today, Detective Valerie Oldham. She'll tell you that within seconds of speaking to the defendant, she suspected that he was involved in the fire. Why? Because he admitted to canceling the home security system that was directly linked to the smoke alarms. The second witness you'll hear from today, Miss Jody Calloway, the next door neighbor and eyewitness to this fire. She'll tell you how the defendant was constantly complaining about his money problems. And on the night of the fire, while it was still burning across the street, the defendant was calling her and asking how he could get his insurance money faster. The last witness you're going to hear from today, Mickey Logan, the home renovator who worked on the house. He'll tell you how he left the defendant alone in the house shortly before the fire. And how once again, while it was burning across the street, the defendant was bragging about the $1 million that were coming his way. Now, like I said at the beginning, the Commonwealth has the burden of proof today. And we gladly accept this. And with your help, we can pick up the mess that the defendant made when he set this fire intentionally. We ask that you find the defendant guilty of arson. Thank you.
And now we can have the defense's opening statement.
Your Honor, opposing counsel, ladies and gentlemen of the jury, Dusty didn't know. In 2022, my client and the defendant in today's case, Dusty Lawrence, suffered a loss with the passing of their great-grandmother. However, she did leave Dusty with something of value. You see, with her passing, she gave Dusty $50,000 and her home, a beautiful historic property called the Caslin House. With this, she gave Dusty the opportunity to start over. Unfortunately, this promise of a new life went up in flames, along with the Casson house. You see, with the inheritance given to Dusty, there was simply too much he didn't know. Dusty didn't know how to sell a home. Dusty didn't know how long and costly renovations could be. And Dusty didn't know just how flammable linseed-based oil stains really were. That's why we're here today. On February 14th, 2023, the Casson house caught fire and burned down. Now, throughout today's trial, you'll be presented with an abundance of evidence and witness testimony that will ultimately lead you to believe that this was nothing but an unfortunate accident. However, as you just heard from the Commonwealth, my client is currently being charged with arson in the second degree. This means that the prosecution has the burden of proof in today's case, meaning they must prove their charge of second-degree arson beyond a reasonable doubt. They must prove that my client intentionally set the Casson house on fire with the intent to destroy the home and to collect the insurance money. Members of the jury, I assure you, the prosecution will not be able to meet this burden today, as the story they will tell you will not corroborate with the evidence we will present. Today you'll hear from Dusty Lawrence, who will take the stand and tell you what really happened to their great-grandmother's beloved house. You'll learn that Dusty wasn't pleased with the initial offers they were getting on the house and decided to renovate. Dusty didn't know that the tax and PBA evaluation would differ so drastically from that of a real market value. Now I ask you to pay close attention to the testimonies of February 14th, 2023. On that day, Dusty and their cousin and contractor, Mickey Logan, were working on staining the Casson house that night. Mickey Logan owns and operates Renewed Kentucky Home, LLC. The stain they chose to use that day was a linseed-based oil stain called West Premium, a highly flammable substance. You'll see that Mickey left early that day, leaving Dusty to finish the stain work and dispose of the highly flammable rags without the assistance of a professional. You will see that Dusty took the rags and compiled them in a corner of the library, unbeknownst of the tragedy that would soon occur. Today you'll also hear from Cole Perry, a fire expert who will teach you why it is vitally important to today's case how the rags were disposed of. Perry will teach you exactly what spontaneous combustion is and how the improper disposal of linseed-based oil stain rags can ultimately lead to a fire. Something Dusty didn't know. You'll also hear from Shay Davis, my client's real estate agent. Shay will testify that in the days leading up to the fire, they received an offer on the Casson house. And this offer was larger than anything Dusty had seen before. Life-changing money. Shay will tell you just how excited Dusty was about this offer, this promise of a new life. Members of the jury, someone about to sell a house doesn't burn it down. Throughout today's trial, we will showcase just how much Dusty didn't know. Dusty didn't know how to sell a home. Dusty didn't know the vastness of the expenses that would accompany it. Dusty didn't know how to remodel a property such as the Casson house. If the fire was accidental, there can be no intent. And if there can be no intent, there can be no arson. The Commonwealth will come before you today and try to prove the intentionality of this fire. However, we will introduce doubt to a logic that simply cannot be overlooked. And you will see that this was nothing but an unfortunate accident. At the end of today's trial, we will come before you and ask that you find my client not guilty. Thank you.
Now, the prosecution, make one of your first witness. All witnesses have been sworn. Go ahead.
The Commonwealth calls Detective Valerie Oldham to the stand.
Detective Oldham.
Can you please state your name for the jury?
My name is Detective Valerie Oldham.
How are you employed?
I'm a detective as well as an arson investigator for the Scarborough Police Department.
How do you become a detective as well as an arson investigator?
I started as a firefighter and went to college where I received my bachelor's degree in fire, arson, and explosive investigations. After that, I became a police officer and was promoted to lead arson investigator for the Scarborough Police Department.
What do you do as a detective and arson investigator?
I determine whether or not a fire was intentional or accidental. If the evidence suggests that the fire was intentional, I file criminal charges against the suspect for arson.
Did you conduct an arson investigation involving the defendant?
Yes, ma'am. I charged the defendant for setting fire to a large historic home located here in Scarborough, known as the Castlin House. The evidence suggests that the defendant staged the fire in a way to appear accidental.
Now, before we talk about the defendant, I want to talk about the Castlin House. Are you familiar with it?
Yes, ma'am.
Your Honor, let the record reflect that I'll be showing opposing counsel what has been previously marked as Exhibit 1 and 4. May I approach the bench? May I approach the witness? Can you identify these?
Exhibit 1 is a photograph of the Castlin House before it burnt down, and Exhibit 4 is a top-down diagram of the first floor of the Castlin House.
Your Honor, both parties have already stipulated that these exhibits are admissible in court here today, so the Commonwealth moves to enter Exhibit 1 and 4 into evidence.
Any objection?
No objections, Your Honor.
That objection admitted.
May be published for the jury, Your Honor. Now, Miss Oldham, what can you tell us about the Castlin House?
As you can see, it's a beautiful older home. It has wood panels, wood eaves, wood trim, and with all that wood, fire is always of concern.
Now, how did you become involved in the investigation revolving the Castlin House?
Last year, on February 14th, Valentine's Day, around 6:30 p.m., I received a call from dispatch about a house fire at this location. When I arrived, the firefighters were already on scene.
Now, what was the first thing that you did?
Well, the home was vacant, so I made a phone call to the defendant, Dusty Lawrence.
Do you see the defendant here in court today?
Yes, ma'am. He's sitting at counsel table wearing the green sweater.
Your Honor, let the record reflect that this witness has just identified the defendant here in court. Now, let's get back to that phone call. What happened?
I quickly suspected that the defendant was involved with the fire.
Why did you suspect this?
You see, the home had a home security system with smoke alarms that were supposed to call 911 right away. However, it was a neighbor who called 911. So I wanted to see why those smoke alarms failed.
Were you able to determine why the smoke alarms did not call 911?
Yes, ma'am. The defendant had canceled the security system a few days before the fire.
How do you know this?
He admitted it. He said it was due to financial reasons.
Financial reasons. Did you look into the defendant's finances?
Yes, ma'am. The defendant's financial struggles would become the main focus of my investigation and eventually led to the motive.
Now, did you investigate the damage to the Castlin House?
Yes, ma'am. Most of the damage was located on the eastern side of the house and spread out from there. However, this area, the library, did become of concern to me because there I found several metal cans of linseed oil.
Now, what was it about this linseed oil that concerned you?
Linseed oil is always of concern to fire investigators because I can show you two very specific ways that you can start a fire with it.
Your Honor, may my witness step down briefly for demonstrative purposes?
Yes, Your Honor. I just asked that I be able to move to further see the demonstration.
That's proper too. Go ahead.
All right, detective, show us how to start a fire.
So imagine we're in a large area with a lot of wood shelves, banisters, or particularly hardwood floors.
Like a library.
Exactly. So linseed oil is applied using cloth racks. You would just get down and apply it into any wood surface by rubbing it in.
Now, how do you set the fire?
Well, first of all, this entire wood floor here, it's no different than if you had just coated it in gasoline. See, now it's very flammable. And it's the same with these rags. They're now very easy to light with a match or lighter.
So a lighter is one way. What's the second?
The second way is very clever, and it's not outside the realm of possibility in this case. You see, if you were to take these rags and instead of lighting them, you were to fold them down into a pile where there's very little airflow, you wouldn't need a person to light the spark. You see, the chemicals in these rags, they heat up and they can catch fire. It's called spontaneous combustion.
And does spontaneous combustion automatically mean that this is an accident?
No, if you're given the proper instructions, you can make this look like an accident.
Thank you. You may be seated. Now, Ms. Oldham, do you know if the defendant had access to linseed oil?
Yes, ma'am. The neighbor and cashier at a local hardware store, her name is Jody Calloway. She's here today.
Do you know if the defendant had the opportunity to use linseed oil?
Yes, ma'am. The defendant admitted to me that he used it after being left alone in the house by the contractor named Mickey Logan. He is also here today.
Now, you've mentioned several times the financial stress. How did this affect your investigation?
Yes, ma'am. I wanted to further investigate the defendant's finances, and while doing this, I found out that he applied for a very large bank loan. However, he was denied.
What did you do when you found out that he was denied for this bank loan?
I went to go speak to the realtor who was trying to sell the house. There I found out that the defendant had no alibi. He had a meeting at 5:30 to be at her office. However, he arrived late, smelling of chemicals.
Now, what did you do with this information?
I was able to obtain a search warrant for the defendant's apartment and car.
Did you discover anything through the search warrant?
Yes, ma'am. The defendant lived in a very small apartment, and inside I found several valuable items being stored there, like a grandfather clock and oil paintings. In the defendant's car, I found an open pack of lighters.
So what are the most pertinent facts of your case?
That there is a defendant who is struggling financially, and then the house burned down.
And why is that important?
Because the defendant had taken out a very large insurance policy on the house before the fire. It's the motive.
How much was this insurance policy for?
$1 million.
Thank you, Your Honor. No further questions.
Process adjourned.
It is important to keep an open mind when examining a fire, correct?
Yes, ma'am, it is.
When you arrived on the scene the night of the fire, you didn't interview anyone.
You mean I personally did not interview anyone, or if interviews were conducted?
You personally did not interview anyone, correct?
No, ma'am. I sent uniformed officers to go to the neighbors and interview them. They had instructions to report back to me if they found anything, and they did not.
So you decided not to start your official investigation until the next morning.
The next day I went in toward the house, yes.
But you did call Dusty Lawrence to let them know that their phone had burned down.
Yes, ma'am, I did, because he was not at the house at the time of the fire.
You admit you were already using an accusatory tone when talking to Dusty, correct?
No, not right away.
So it's your sworn testimony you weren't using an accusatory tone?
I was, after he said that he canceled the home security system. I wanted to question him and see why he thought that was a good idea. That's when I may have used an accusatory tone, but that was not right away.
The next morning you went back to the scene, correct?
Yes, ma'am, I did.
You determined that the fire started in the library.
Yes, and the ignition source was the linseed oil.
You then went back to your office.
Yes, ma'am, I did.
At your office, you realized you had received a voicemail from someone at Federal Ranch Insurance.
Yes, ma'am.
Your Honor, at this time, I'll be referring to what's been previously marked as Exhibit 13. Let the record reflect I'm showing a copy to the opposing counsel. And would the court like a copy? May I first witness? This is a copy of the voicemail left to you by Federal Ranch Insurance, correct?
Yes, ma'am.
And it's a fair and accurate copy?
Yes, ma'am.
Your Honor, at this time, we move this document into evidence as Defense Exhibit 13.
Any objection?
Yes, Your Honor. There are several reasons that we're objecting to this document. First of all, the hearsay of this document is very blatant. This document is also much more substantially prejudicial than probative under Rule 403, and it does have an unfair legal conclusion in it.
Which is?
That the fire was accidentally started or intentionally started.
Yes, Your Honor. According to hearsay, we are not using this to prove the truth of the matter asserted. We as the defense actually believe that all of the contents on this document are false. We are rather using it to show the subsequent course of action taken by Detective Oldham. After receiving this voicemail, she began to suspect that they were on to something about this being arson.
Your Honor, while that might fit the hearsay exception, there is still substantially more prejudicial than probative information, and it does still have an unfair legal conclusion.
I will allow the exhibit. I believe that it is relevant, and I will instruct the jury to consider it this way. Its probative value is not outweighed by its danger of unfair prejudice. It has probative value as to the steps taken by the officer, why they took those steps. But the jury will only consider it for that purpose and will not consider a hearsay statement as to accidental or intentional setting of fire. Go ahead.
Yes, Your Honor. May we publish to the jury? Based solely on Jody Calloway's statements, Federal Ranch says they had reason to believe this fire was intentional, correct?
That is what Federal Ranch believes, not me.
You began looking at the red flags in this case?
Yes, ma'am, but that's not because of this email. I began investigating the defendant because he canceled the home security system and because he wasn't at the house at the time of the fire. This email almost had no effect on my investigation.
Detective Oldham, I'm not asking you why you looked at the red flags. I'm just simply asking that you did look at the red flags. Is that correct?
Yes, ma'am, I did.
You got this email less than 24 hours into your investigation, correct?
Yes, ma'am.
And less than 24 hours into your investigation, you already began to suspect Federal Ranch might be on to something.
I suspected that the defendant was involved with the fire after they admitted to me about canceling the security system. That's when I began to investigate them and suspect them.
So you did begin to suspect Federal Ranch was on to something, is that correct?
I believe that the defendant set this fire intentionally before the email. The email just further went on to say that this might be something to look into.
So that's a yes to my question.
Yes.
Jody Calloway stated there was a car in front of her home with a license plate that began with the number 8.
Yes, ma'am, that is what she told me.
But she also said it could have been a 3.
Yes, ma'am, that's what she said.
You looked up Dusty's license plate, didn't you?
Yes, ma'am, I did. It was a dark 4-door car with a license plate starting as an 8.
But you didn't look up how many other vehicles matched this description with the license plate that began with an 8.
Do you mean that I didn't look up any other car in the entire Scarborough?
That's correct. You didn't even care to check if there were other cars that matched this description in the area.
No, the defendant's car matched it. I looked at that one.
When it comes to how the fire started, you agree that improperly stored linseed oil rags can spontaneously combust, correct?
Yes, they absolutely can, as I demonstrated.
They can ignite without any outside heat source.
Yes, like I said, if the person were to leave those rags there, they could leave the house by the time that the fire started. It's very important in this case to admit that this could have been done accidentally on purpose.
All fires require 3 components, correct?
Yes, heat, fuel, and oxygen.
As it dries, linseed oil mixes with oxygen in the air, releasing heat as part of the chemical reaction.
Yes, that is when these chemicals in the rags can get trapped and heat up, and that's what can cause the spontaneous combustion.
So when the rags are trapped in a pile, much like the situation that we're seeing today, it can reach ignition temperature. Is that correct?
Yes, ma'am, it can. That's why I demonstrated how these rags can catch fire. This spontaneous combustion is very important in this case. It clearly displays the way that the defendant could have set the fire intentionally.
But you acknowledge the possibility that this whole thing could have started due to the improper storage of linseed oil rags. Is that correct?
Yes, ma'am. It is very possible that this fire started by those rags being in a pile, like I said.
Thank you, Your Honor. No further questions.
You redirect.
There's no redirect, Your Honor.
I thank you.
Maybe tender our exhibits to the bench.
I will save you side time. I do have all the exhibits, but you will use your time as you want to. Next, please.
Yes, Your Honor. Commonwealth calls Jody Calloway to the stand.
Jody Calloway.
Please state your name for the record.
My name's Jody Eria Calloway.
And where do you live, ma'am?
I live at 755 Elm Street, right across the way from the Castle House before it burnt down.
Who else lives in your house with you?
Well, I'm a widow. My husband Angus, he died a few years ago. But, you know, he left me with this little, annoying, yappy dog named Thistle. So it's just me and him who live there now.
Were you home when the fire happened?
I was. And I saw many strange things before the fire happened.
I want to talk to you about the strange things, but before I do that, I want to start basic. What do you know about the Castle House?
Well, Naomi Lawrence, the previous owner of the Castle House, we were best mates. I would come over to her home and I would look at her garden. It was beautiful, but the inside of the house, it needed some work to say the least.
Now, do you know Naomi's grandson, Lieutenant Dusty Lawrence?
I do. He only really asked me questions about insurance.
Are you familiar with insurance?
My husband Angus, before he passed away, I used to work at an insurance company. Dusty came up to me and asked me for a company to get an insurance loan from. So I gave him the name of a company and he bought a very large policy on the Castle House.
Did you see the defendant very often around the Castle House?
Well, you know, he came and he went, trying to sell Naomi's home for $1 million, but no one ever bought it.
You mentioned you saw strange things earlier. I want to talk about those. Where did that happen?
It was a few days before the fire. It happened at the hardware store. I work there part-time. I have to get out of the house before I go stir crazy.
And what happened at the hardware store?
Well, Dusty came in his face. It was all scratched up. Something was wrong. So I asked him, "Love, what's wrong?" And he said, "I'm stressed."
Did the defendant tell you why he was stressed?
Well, you know, he kept telling me all about his money troubles and about how the Castle House is just eating away at his pockets. He couldn't afford the renovations.
Did the defendant buy anything while he was at the hardware store?
He did. He bought a can of linseed oil.
And are you familiar with linseed oil?
I am. Anyone who buys linseed oil, I give them a warning sheet telling them all the dangers of linseed oil if not stored properly.
And would you recognize this sheet if I showed it to you today?
I would.
Your Honor, at this time I am showing opposing counsel what has been previously marked as Exhibit 6. And approach the witness, Your Honor. Can you please identify this exhibit?
This is the warning sheet I give every customer who buys linseed oil, including Dusty.
And are you familiar with this?
I am.
Your Honor, at this time the Commonwealth moves to Exhibit 6 into evidence.
No, Your Honor. Pursuant to stipulation 8, this is admissible.
Thank you.
What happened once you handed the defendant the sheet?
Well, he stood there and he read it.
And what happened after that?
Well, he was standing there reading it, and he looked up at me and said, "A fire? Should I be so lucky?"
And what did you do next?
Well, I was flabbergasted. I mean, I felt like I had just given him instruction on how to burn down the Castle House. Well, I guess he saw my face, and he started telling me again all about his money troubles, and about how the Castle House was just too much to handle, and that he just couldn't afford the renovations.
I want to talk to you about the day of the fire. What were you doing earlier that day?
Well, Thistle, bless his heart, we're on a strict schedule. He's 22 years old after all. His bladder's the size of a wee pea. So we have to go outside before we go to bed.
Did you see anything while you were outside?
Well, Thistle was taking a wee. I looked over at the Castle House, but it wasn't on fire yet.
So what did you do next?
Well, I go back inside, take Thistle off the leash, and I go straight to bed.
How did you discover the Castle House was on fire?
Well, you know, I'll give Thistle credit where credit is due. I guess he saw the fire or he smelled it, something, and he started barking like a wee banshee. Woke me clean up out of my sleep.
And what did you do once you learned the house was on fire?
Well, I needed to call somebody. So I called emergency services, and straight after, I called Dusty.
And how did that call with Dusty go?
Well, I called Dusty, and the only thing he was asking me was about insurance and when will I get my money back? How do I file a claim? How can I get my money faster?
And what did you do next?
Well, I was fuming. There I am watching his great-grandmother's house burn down, and the only questions he can ask me is about insurance. It's disgusting.
Thank you, Your Honor. No further questions at this time.
Cross-examination.
Yes, Your Honor. Miss Calloway, you are the cashier who sold Dusty Lawrence the West Premium wood stain,
I am.
and you're required to give a technical sheet.
Yes, as to do with everyone, including Dusty.
It states that this stain is flammable.
It does. It says caution right here with the big red text and the triangle, or the square, yeah.
And it also states that if not stored properly, it could lead to a fire.
And it does, where it says caution in big red letters.
Now, Miss Calloway, you only told him once that this stain was flammable.
Well, darling, he had the sheet and he read it, so yeah.
And you only told him once that if not stored properly, it could lead to a fire.
I mentioned it, but he was reading the sheet.
While he was reading the sheet, you interrupted him.
What are you referring to? What's I interrupted with?
Your own statements.
What statement are you referring to?
While he was reading the sheet, he mentioned that if a fire happened, he would be lucky.
Yes, he said a fire. Should I be so lucky?
And while he was reading the sheet, you started to scold him.
I did. It's inappropriate to say the least.
But you did interrupt him.
I did, because it was inappropriate to say a fire. Should I be so lucky while reading a warning sheet?
Now, Miss Calloway, I would like to turn your attention to the night of the fire. Around 5 p.m., you took a dose of cold medicine.
I did. It was just some NyQuil that you can buy over the counter.
And this medicine really knocks you out.
I mean, I was a wee bit sleepy, but I wasn't drunk or anything.
But this medicine does really knock you out.
It makes me sleepy, yeah.
Now, you went outside around sunset.
Yes, to take Thistle out.
And you claim you saw a car by your house.
Yes, a car was parked in my driveway. It was a dark, four-door car. I don't know the brand. I don't know American brands, to say the least. But, yeah, that's about it.
You claim it started with the number 8.
Yes, but I don't know the full license plate number. I couldn't give you that.
And you admit it could have started with a 3.
As I said, I don't know the full license plate. I don't have it memorized.
You also mentioned looking at the Castleton house at this time.
I did. I saw something in the window. A person, a shadow, a box, something.
Now after this, you went back inside.
I did.
Went back to sleep.
I did.
And were woken up to see the Castleton house in flames.
I did, and then I called 911 and I called Dusty.
Your Honor, at this time, I will be referring to what has been previously marked as Exhibit 7. Let the record reflect I'm showing the present counsel a copy. May I approach the witness? Thank you. Now, Miss Calloway, this is the 911 call, correct?
It seems to be.
And it's fair and accurate?
Looks like it.
Your Honor, at this time, the defense would like to move this exhibit into evidence as Defense Exhibit 7.
Any objection?
No, Your Honor.
No objection.
May be published to the jury.
Maybe.
Now, Miss Calloway, in this 911 call, you never mentioned seeing anything in the Castleton house.
No, I was more worried about the fire that was going on.
But during this conversation, you mentioned your medication 3 times.
I just said that I was woozy and I wasn't feeling so well, but I still got the point across that there was a fire.
But you did mention your medication 3 times.
I just said that I was woozy.
Miss Calloway, I would like to look at this exhibit, and I want you to read aloud certain lines. May I approach the witness? Thank you. Right here, it is the 8th line. You say, oh my, I can't believe this. I have been taking medication. Did I read that correctly?
You did.
Yes, so Ms. Calloway, you did mention your medication.
I did.
And you also mentioned twice how hard it is for you to think.
I did, but I still got the point across that there was a fire.
Now, you could reasonably say that this call was about 2 minutes long.
About so, yeah.
So in 2 minutes, you mentioned either your medication or how hard it is for you to think.
5 times.
Because they were asking me some questions, it was a bit hard to think, all the adrenaline, but that would be true.
Now, Ms. Calloway, after this, you called Dusty Lawrence
I did.
and told him that the house was aflame.
Objection, Your Honor, hearsay.
Any response?
Your Honor, I believe in court she has already testified that she did in fact tell Mr. Dusty Lawrence that the house was on fire.
Any response?
Your Honor, we have never referenced this out-of-court statement. This is being used to prove the truth of the matter asserted, and it is hearsay.
I'll sustain the objections.
Please respect, Your Honor.
Sure.
Thank you. Ms. Calloway, during this call, you claimed that Dusty was only asking questions about insurance money.
That would be true. He asked me how the fire was, and I said, it looks like a total loss. But straight away, and with more concern and passion, he said, well, how do I get my insurance money? How can I file faster and get it quicker?
But Ms. Calloway, the actual first question he asked you is if the house could be saved.
Aye, that's what I just said.
Now, Ms. Calloway, you believe that you wouldn't like Dusty to be your neighbor.
No, I don't do well with teenagers. They're loud, rowdy, and I have thistle. That's enough on my hands.
You believe Dusty Lawrence is spoiled.
Some things that Naomi told me I didn't agree with, but any grandchild is spoiled.
And you believe that he took advantage of Naomi Lawrence.
I think that she was a very giving person.
You yourself even gave a statement to the insurance company about the fire and about your call with Dusty.
Well, I used to work at the company that you're referring to. I know how the process works. They were going to call me anyway, so I just got it out of the way.
And after Mr. Lawrence was charged, you told all the neighbors about what had happened.
Objection, Your Honor, hearsay. The witness's own statements.
Response?
Your Honor, we are not showing this to prove the truth of the matter asserted. We are simply just showing what has happened and the subsequent course of why she is here in court today.
Your Honor, that is being used to be directed to prove facts, and that is the truth of the matter asserted.
I'll let her answer the question that she said things to other neighbors, but not specifics of what she said.
Yes, Your Honor.
Yes, Your Honor. Ms. Calloway, you did tell the neighbors after Dusty was charged about what had happened.
Well, yeah, there was a fireball in the neighborhood. I think everyone would have noticed.
However, Ms. Calloway, you don't know if Mr. Lawrence was the one that started the fire.
Well, all I was saying was there was a fire and it was pretty big, and it was at the Castlin house.
But you don't know
No what?
that Mr. Lawrence was the one that started the fire.
No, all I know that there was a fire.
Thank you, Your Honor. I have no further questions.
Be correct.
Yes, Your Honor, briefly. Do you remember being asked questions during your cross-examination about taking medicine?
I do.
Now, were you taking any medicine a few days before the fire when you were talking to Dusty at the hardware store?
No, I wasn't taking anything at all.
Were you taking any medicine at all when he was telling you about his money troubles?
No, I was as sober as a judge, they would say.
Thank you, Your Honor. No further questions at this time.
No, Your Honor. I simply just asked to retrieve my document and send it to the bench.
That's fine. Thank you. The witness is excused. Prosecution may call your next witness.
Yes, Your Honor. The Commonwealth calls Mickey Logan to the stand. Can you please state your name for the record?
My name is Mickey Logan.
And how are you employed?
I remodel and flip homes to sell. I'm also the owner of Renewed Kentucky Home, LLC.
What is your connection to today's case?
I did some work on the Castlin house for Dusty Lawrence.
Do you have any knowledge about the fire?
I do. Before the fire, I left Dusty alone in the house with the linseed oil. I also explained to Dusty on no less than 3 occasions how to properly handle linseed oil.
How did you end up working at the Castlin house?
Me and Dusty are actually cousins. He was the one who inherited the house from someone on his side of the family.
What can you tell us about the house?
It was an older house. It had some potential, but it was in some pretty rough shape.
And how was it in rough shape?
Well, the outside was absolutely gorgeous, straight out of Gone with the Wind, but the inside was more like the Brady Bunch. Let's just say that it needed my touch.
You mentioned earlier you were cousins with the defendant. So does this mean you did all this work for free?
No, of course not. He still hired me. He gave me a big down payment for materials and labor, and I still had my regular fee of 10% of the selling price.
Did the defendant ever mention how much he wanted to sell the house for?
Yeah, $1 million.
You flip homes to sell here in this town. Are you familiar with what they typically sell for?
I am.
Based on your knowledge, did you think that $1 million was a reasonable price for the Castle house?
If you're talking about when Dusty first inherited the house, no. So that's why we sat down and we worked up a plan.
Your Honor, let the record reflect I'm approaching opposing counsel with a copy of this plan, which is Exhibit 2. Very first witness. Can you please identify this document?
Yes, this is the renovation agreement that I had with Dusty.
What is the purpose of this document?
I use it pretty regularly in my business. Me and the client work out what the costs are going to be, and then based on those costs, we establish a plan. And after all that stuff is done, the client signs it like Dusty did.
Your Honor, the Commonwealth moves to enter this as Exhibit 2 at this time.
No, Your Honor.
Admitted.
What did you and the defendant agree to in this contract?
We agreed to gut and remodel the kitchen and the bathrooms. We also agreed to redo all the carpets and refinish the flooring. We also agreed to redo the driveway, which that in and of itself would cost $25,000. This was going to cost a lot of money.
At the time of the fire, had all of that work been completed?
No, we were nowhere close. We were just a couple of weeks into the renovations.
You mentioned needing to refinish the wood floors. Let's talk about the use of linseed oil as a wood stain. Are you familiar with it?
I am. It's some pretty dangerous stuff, but it's really not that complicated.
How do you know that linseed oil is dangerous?
It's fairly common knowledge in my profession that you can get this stuff to start a fire without a match. I mean, it's crazy, but like I said, it's not that complicated.
How did the two of you use it?
Well, we started using it around noon in the library. Before we started, I made sure to trip the circuit breakers going to that part of the house, so it's a little chilly in there. We were working in sweatshirts and jeans. As it came around 4:30 p.m., I had to finish up because I was going to go on a dinner date with my wife as it was Valentine's Day. And as it came around that time, Dusty kept insisting that I leave. He even told me to just go on and get home. So I left him alone in the house with the linseed oil.
Before you left, did you feel comfortable leaving the defendant alone to handle the linseed oil?
I did. It's not that complicated. Dusty said he'd read the warning sheet, and I told him what to do.
How much more work was there left for the defendant to do?
Not much. All he had to do was put up the rags that we had been using.
Let's move on to later that night. How did you find out about the fire?
Well, I was in the middle of my hot date when I get this text from Dusty.
What did the defendant say?
He said that the house was on fire and was probably a total loss. I asked him why the security system had not alerted the fire department in time to save the house.
And what did the defendant tell you about the security system?
He said he had canceled it. I mean, I was absolutely furious. It's completely insane for Dusty to have done that, and there was no excuse.
As someone who renovates homes, what is your understanding of what the security system is there for?
It's there to protect everything. There's smoke detectors that can alert 911 so the fire department can respond in time. There's also cameras and sensors that can let us know if someone was in the house at the time.
Did the defendant ever mention why he canceled the security system?
Yeah, he mentioned something about losing his job.
Let's go back to that contract that lists all the expenses. Your Honor, may I publish Exhibit 2 to the jury? Down here at the bottom, where it says estimated costs, how much were these renovations going to cost the defendant?
Over $60,000.
Were these the only expenses the defendant was going to have to pay in regards to the Castle house?
No, these were just the maintenance fees. Dusty still had all of the monthly upkeep costs, which are going to cost a lot of money. Remember that movie, The Money Pit? Well, that's exactly what this was.
You mentioned monthly upkeep costs. Do you know what these were in order to keep the house running?
Yeah, it includes things like electric, water, gas, monthly landscaping fees, property taxes, and of course the monthly payments for insurance.
Insurance. Let's talk about that. Did the defendant ever mention insurance?
Yeah, he mentioned insurance while the house was on fire.
What did he tell you?
After complaining about all of his financial troubles, Dusty said, "But don't worry, I have $1 million insurance policy. It's going to take care of everything."
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor.
Mr. Logan, after the fire at the Casson house, you were interviewed by Detective Oldham, correct?
That is correct.
Now, you had told them that Dusty had moved the grandfather clock and paintings out of the Casson house.
Objection, Your Honor, to hearsay on this witness's past statements. These are out-of-court statements used to prove the truth of the matter asserted and are not allowed.
Your Honor, we are not using these to prove the truth of the matter asserted. Instead, we're using this to show a subsequent course of action. These statements were going towards the investigation in this case, which is very relevant, as this is going to prove what we are talking about. And these statements go to prove the subsequent course of action as to how this conversation is going.
Your Honor, may I respond? If they're going to argue that this is showing an action, they must specifically lay the foundation for that, and they have not done so.
I'll overrule the objection. I believe the witness can be asked about his comments as well as his actions.
Yes, Your Honor.
So, after the fire, you were interviewed by Detective Oldham, correct?
Like I said, I was.
And you had told them that they had moved a grandfather clock and paintings out of the Casson house.
That's correct. I told Dusty to, just to create some space, and honestly, this is one of the few times I don't think Dusty did anything wrong here.
Yes, you were the one who initially suggested to Dusty to move the furniture out of the apartment.
Like I just said.
Now, on the night the Casson house burned down, you were staining that day, correct?
That is correct.
The stain you chose to use was a linseed-based oil stain
That's correct.
called West Premium.
Yes.
This is a highly flammable substance.
Yeah, but it's really not that complicated.
But the rags are known to catch on fire without any sort of spark if not disposed of properly.
They could.
This even happened to you when you accidentally left some rags in a shed.
That is correct.
You didn't get an airtight container for the rags, did you?
That was a long time ago, and I don't remember a lot of the specific details about that.
But you didn't get an airtight container for the rags.
I don't think I did, but like I said, that was a long time ago.
You didn't fill that container with the water.
That is correct.
And you didn't put the rags in the water.
That is also correct.
These are the proper disposal procedures for linseed-based oil stains?
Yes, and when I was instructing Dusty on those 3 occasions, I made sure to tell him that.
And the shed caught fire and burned down due to spontaneous combustion.
Like I've been saying, I don't remember a lot of the specific details about that.
But the shed did burn down, correct?
Oh yeah, it did.
So even professionals like you with experience can make mistakes with the stain.
It's possible, yeah.
Just like it happened to you.
Yes.
Now, on the night the house burned down, you told Dusty you needed to finish staining as soon as possible.
I did. I wanted to get to my date with my wife.
So you had dinner reservations.
Yes, I did.
Now, if you and Dusty had both stayed, you would have finished around 4:30 p.m.?
It's possible. I really don't know when we would have finished.
So, it is your sworn testimony that you wouldn't have finished around 4:30 p.m.?
That's when I started finishing up, yeah.
But you decided to let Dusty finish up on his own.
Yeah, it's not that complicated. I told him what to do multiple times.
Now, you did not get an airtight container for the rags, did you?
I did not know.
And you didn't fill that container with water?
I did not know. We were still finishing up, and you want to make sure the stain's all gone before you seal it.
But you didn't fill that container with the water?
Like I said, we weren't done yet, and you need to make sure the stain's all gone before you put the water in it, and then you seal it.
But you weren't around to make sure that these things were properly taken care of?
No, but I had explained to Dusty on no less than 3 occasions about how to properly dispose of it.
Yes, you were fairly sure you told Dusty how to dispose of the rags?
On the night of the fire?
Just in general, yes.
In general, I'm confident I explained to Dusty.
But in retrospect, you could have had him repeat the instructions back to you to ensure he knew exactly what he was doing.
Objection, Your Honor, to speculation. This is a hypothetical situation.
Your Honor, I'm not asking the witness to testify to the mindset of someone else. I'm simply asking if he believes that this is something that he could have done. Furthermore, this is a cross-examination. If he doesn't believe that there's any truth in this statement, he can say no.
Your Honor, if I may, This is still a hypothetical situation on something that could have happened, and that is asking my witness to speculate, and is simply not allowed.
I'll sustain the objection. Go ahead.
Yes, Your Honor.
So you, a trained professional, did not dispose of the highly flammable rags you had been using that day.
I do not know. It doesn't take a trained professional to dispose of them.
But you left it in the hands of a person who has no experience with the stain.
I left it in the hands of a person who I explained to on no less than 3 occasions how to properly dispose of it.
But I'm not asking about what you explained to Dusty. I'm simply asking that you left it in the hands of a person who had no tactical experience with the stain.
You don't need experience to dispose of the stain.
But you did leave it to him.
That is correct.
And just like the shed, the Castlin house caught fire and burned down.
Yes, it did.
Thank you, Your Honor. I have no further questions at this time.
You read that?
No, Your Honor. May we tender exhibits to the bench?
This is excused. Includes the case in chief for the prosecution. Which parties like to brief recess before we start? That's the case.
Yes, Your Honor.
Yes, Your
We
Honor.
only have 5 minutes recess.
Please introduce yourselves to the members of the jury.
My name is Cole Perry.
Mr. Perry, what do you do for a living?
I'm a fire investigator and analyst, and I work for Izzone Associates in Midland City, Midlands.
Do you have an educational background relevant to your field?
Yes, I obtained both a Bachelor's of Science and a Master's degree, both in chemical physics, and both from Midland State University.
How did a degree in chemical physics lead to fire investigation?
After I graduated, I learned that Federal Ranch Insurance was looking to hire fire investigators. I applied and I got the job, and that eventually led to my career in fire investigation.
Do you have a continuing education relevant to your field?
Yes, I do. Through the International Association of Arson Investigators, I'm both a certified fire investigator and a certified fire and explosion investigator.
Do you happen to be published?
Yes, I've written several lectures and I've written several articles and given several lectures at conferences, mainly on the topic of investigating insurance claims where there is a suspicion of arson.
How did you come to work for Izzo and Associates?
I was bought out by Federal Ranch after some restructuring, and then I got a job with Izzo and Associates. I mostly work with owners of large commercial properties to pinpoint and mitigate fire risks, as well as educate executives.
Mr. Perry, how are you involved in today's case?
I reached out to Defense Counsel about testifying here today, and they hired me to perform a forensic analysis of the prosecution's case.
What was your goal of this forensic analysis?
I wanted to determine, based off the materials that I reviewed, if the fire that occurred on February 14th, 2023 at 754 Elm Street was set intentionally or not.
What materials did you review?
I reviewed the affidavits of Mickey Logan, Jody Calloway, Val Oldham, Shay Davis, and Dusty Lawrence, as well as several documents including a map of the Castlin house, a copy of the insurance policy, and a transcript of a phone call from an insurance agent to Detective Oldham. And these materials were sufficient for my investigation.
With these materials, how did you go about starting your investigation?
Whenever I start a fire investigation, there are 3 things that I'm looking for. 1, I want to find the point of origin of the fire. 2, I want to know what the fuel to the fire was. And 3, I want to know the cause of the fire. And that means whether it was set intentionally, or whether it was accidental, or whether it can't be determined.
Did you happen to take any sort of approach when starting your investigation?
Yes. With any investigation, but especially with fire investigations, the most important thing is to keep an open mind. Because of the nature of fire, in order to call something arson, you have to rule out every single other possibility. And this means it's especially important to avoid confirmation bias.
Mr. Perry, what is confirmation bias?
Confirmation bias is when an investigator finds a piece of evidence in a case, and they take that piece of evidence and they make a conclusion. But then that often means that they will view the rest of the pieces of evidence through the lens of that first conclusion, and that means that they can disregard other possibilities. It's extremely dangerous to fall into the confirmation bias trap, and any good investigator will know how important it is to avoid this.
Mr. Perry, were there any other important factors you took into consideration throughout your investigation?
Yes. Again, whenever I examine a fire, I look for red flags. Red flags are possible indicators that arson occurred, and the more red flags present, the higher the chance that arson occurred. However, it's important to note that red flags have no magic number that directly indicate arson. Each one of them has to be looked at in context.
What do you mean by that?
Well, for example, I had a case in the past where 5 of the 7 red flags were present, and that's a lot. But in reality, what happened was the house was struck by lightning, and that's why it burned down. So red flags don't directly indicate arson.
Mr. Perry, are you aware of the red flags presented by Detective Oldham in this case?
Yes, I am. Detective Oldham found financial stress, the property was insured, no one was in the home at the time of the fire, valuable items had been removed from the home, and the security system had been deactivated. But many of these red flags can be explained by context.
Are you willing to provide some context for these?
Yes. As for the removal of valuable items from the home, Dusty did this at the advice of Mickey Logan. And as for the security system being turned off, Dusty did this at the advice of Shay Davis, his realtor. And finally, for financial stress, yes, Dusty was a little bit low on liquid cash, but financial stress is relative. He was also sitting on a house that had multiple 6-figure offers on it. So again, these red flags don't directly indicate arson just because they're present.
Mr. Perry, are you aware of Detective Oldham's conclusions throughout this case?
Yes. Based on my review, Detective Oldham concluded that the fire began in the library and that the linseed oil-based stain that was used in the library was the fuel to the fire. However, Detective Oldham then went on to conclude that the fire was set intentionally. And based on my review, I just don't think there's enough evidence to support this claim.
Do you believe there's another way this could have been set?
Yes, accidental spontaneous combustion.
Mr. Perry, what is spontaneous combustion?
When most people think of spontaneous combustion, they're a little bit off on their definition. Take that black podium over there. The spontaneous combustion isn't just that podium bursting into flames with nothing touching it at all for no reason. That's not logical. Instead, spontaneous combustion just defines any fire that starts without an apparent ignition source, like a match or a lighter.
In this case, is there a reason that the fire could have started without an ignition source?
Yes. Based on my review, when Dusty left the library after staining, he kind of smushed the rags together in a pile by the library door.
Your Honor, at this time, I'll be referring to what has been previously entered as Prosecution Exhibit 6. May I approach my witness? Thank you. Mr. Perry, what is this document I just handed you?
This is a technical data sheet that details the dangers of using a linseed oil-based stain.
And is it fair and accurate?
Yes, it is.
Mr. Perry, what does this sheet say about the use of rags in the storage of them?
It says materials such as rags used with this product may begin to burn by themselves without any heat source. However, it does not also mention that compacting those rags can cause a fire to start faster, or that is the real danger in spontaneous combustion.
Mr. Perry, are you aware of how Dusty Lawrence disposed of these rags?
Yes, Dusty Lawrence piled the rags in by the door of the library.
And is this significant?
Yes. The reaction that takes place when linseed oil-based stain cures is exothermic, and that means it releases heat. So I want you to picture all those rags at the bottom of the pile. They're being compacted by the rags on top, and the rags on the bottom are all releasing heat at the same time. But because they're insulated by the rags on the top, there's nowhere for that heat to dissipate. So that pile just keeps getting hotter and hotter and hotter until eventually it reaches reaction ignition temperature.
Mr. Perry, is this common?
Yes. The National Fire Safety Association estimates that 14,000 fires happen in the U.S. alone every year because of the accidental improper disposal of this type of material.
Mr. Perry, based off of your investigation and review, what do you have to say about what happened the night of February 14th?
Based on my review, I could not rule out the possibility of accidental spontaneous combustion. And therefore, I cannot say with certainty that the fire was set intentionally.
Thank you, Your Honor. I have no further questions.
Cross-examination.
Yes, Your Honor. Now, Mr. Perry, you have no background in law enforcement, do you?
I do not.
In fact, you've never testified in a criminal case before today.
Yes, this is my first.
You always testify for plaintiffs, correct?
Yes, well, in the past, yes.
And these plaintiffs are oftentimes suing insurance companies for fire loss that they claim are accidental, correct?
Yes, this is correct.
So when someone needs to call an expert to come to court and say that a fire was accidental, you're the person to call.
I wouldn't say so. People hire me to perform investigations and analysis, and I review the facts and I come to a conclusion based on that. I don't reach the same conclusion every single time.
Well, Mr. Perry, I want to talk about the conclusion that you came to in today's case and how you conducted it. When you talked to the defendant, he never told you that this was an accident, did he?
Well, I actually never talked to the defendant. I reviewed affidavits.
That's right, Mr. Perry. You never spoke to the defendant. So let's take a look at all the other people in this case with knowledge that you never spoke to. Let's start with Jody Calloway, the next door neighbor, an eyewitness to this fire. You never spoke to her, did you?
I didn't, but my job in this case is not to act as an investigator. I'm an analyst, which means I review the investigation that has already been conducted by Detective Oldham.
Now let's move on to Mickey Logan, the home contractor. You didn't speak to him either.
Again, I'm just an analyst, but I did read his affidavit, yes.
Detective Valerie Oldham. You never spoke to her.
No, but I did examine her findings.
And on your own side of the case, the realtor Shay Davis, you never spoke to her, did you?
No, but again, I have reviewed her affidavit.
Well, so as you sit on this stand right now, this is the first time you have ever seen any of these people?
Yes, but again, I'm just an analyst. My job is just to review information that has already been found.
Yes, Mr. Perry, as you keep saying, you are just an analyst, but you would agree with me that the one thing that your analysis is missing is the ability to ask questions and clarify about their statements with any of these people, correct?
I wouldn't necessarily say that's missing from my investigation. I found all the information I needed from these affidavits, and that allowed me to come to my conclusion.
Well, you say it's not missing, but I am correct in saying that you didn't ask questions to any of these people.
Yes, you're correct.
Now I want to talk about the fire. You mentioned several times on your direct that about spontaneous combustion. Now, this can take up to 2 hours, correct?
It can, but there are several factors that can allow it to go faster, such as compaction of the racks.
Yes, faster, like 30 minutes, right?
Yes, this is true.
Now you mentioned several factors. These factors are catalysts, correct?
Yes, catalysts allow a reaction to occur faster.
Exactly. Catalysts can include things like direct sunlight or high temperature, correct?
Yes, those are potential catalysts.
Now, first I want to talk about the temperature. This fire happened on February 14th of 2023, correct?
Yes, that's correct.
And that's winter in Kentucky.
Yes, this is true.
And you heard Mickey Logan testify that he had to wear a sweatshirt that day.
I did, yeah.
Now, next I want to talk about the direct sunlight. Your Honor, may I approach the bench to retrieve Exhibit 4 of the diagram? Now, I believe that the jury should still have their copy. Now, Mr. Perry, I'm going to hold this up, and we're going to discuss it just a little bit. Do you see the compass that points north?
Yes, I do.
Now, this fire happened around 5:30 in the afternoon, correct?
Yes, that's correct.
Now, you would agree with me that the sun rises in the east, correct?
Yes, I agree.
And it sets in the west.
Yes.
Now, if you look on this diagram, I do believe that the library is on the east side of the house, correct?
This is correct.
So at the time of the fire, the sun would have already risen in the east and would have now been setting in the west, correct?
Yes, this is true.
So at the time of the fire, there was no way for any direct sunlight to have entered the library?
Not directly, but I think what's missing here is that...
Mr. Perry, I'm not asking what's missing. I'm simply asking if there was no way for direct sunlight to enter the library.
Not direct sunlight, no.
So for this fire to have happened, it would have had to do so in the middle of winter in a room with no direct sunlight?
Yes, but from my
Thank you, Your Honor.
understanding.
No further questions. May I return this to the bench?
Briefly, Your Honor. Mr. Perry, on the cross-examination, you were asked about the temperature of the room. Is temperature relevant?
Temperature can cause a reaction with spontaneous combustion to occur faster. However, there are several potential catalysts for this reaction, and the absence of a high temperature or direct sunlight does not eliminate the possibility that these rags were smushed together. That is what I believe is the X factor in this equation.
And why do you believe that the smushed rags are the X factor?
Objection, Your Honor, to improper rag. Whether the rags were smudged was not mentioned in my cross whatsoever.
Your Honor, may I respond? During her cross-examination, they are trying to pinpoint what certain factors may have led spontaneous combustion to appear faster, or if spontaneous combustion would take about 2 hours to appear on February 14th. We are just clarifying to the jury that this spontaneous combustion could in fact take place faster than what the prosecution is trying to claim.
Any further response?
Yes, Your Honor. While we did mention temperature and direct sunlight, there was no mention about the crumpling of the rags at all, so therefore this question is outside of the scope of my cross.
In response to your questions, the witness did comment about the density of how much the rags were found on, so
Yes, Your Honor.
Thank you. Mr. Perry, why do you believe the compaction of the rags was the X factor?
When those rags are compacted together, the insulating properties of the rags on the outside allow the rags on the inside to continue getting hotter. Reaction ignition temperature is only 120 degrees. So I believe even in the absence of direct sunlight or even in cold temperatures, because these rags were compacted so much, the fire still could have started by a spontaneous combustion accidentally.
Thank you, Your Honor. I have no further questions.
need to cross.
No, Your Honor.
Thank you. Witness is excused. Your next witness for the defense.
Your Honor, at this time, the defense calls Shay Davis to the stand.
Shay Davis.
Please introduce yourself to the members of the jury.
My name is Shay Davis.
Miss Davis, what do you do for a living?
I'm a real estate broker and president and principal broker of Davis Realty LLC.
What does being a real estate broker entail?
Well, I oversee all of the agents at my firm, and I assure that they, as well as all of my other employees, are acting ethically and within the law. A lot of people don't know the difference, so they'll use the terms real estate agent, realtor, or broker interchangeably, but as long as I'm getting my commission, I don't really care what people call me.
Miss Davis, do you mind to explain to the jury how you're involved in today's case?
Yes, Dusty Lawrence hired me to help sell a piece of property that he inherited in 2022.
What did Dusty want to do with this property?
Dusty wanted
Your
to...
Honor, speculation upon what the witness wanted to do.
In response.
Your Honor, I'm not speculating to what the witness wanted to do. I'm simply asking the realtor, as they have their own rationally based observations and perceptions, given that they were the realtor. They've had multiple business meetings, and they would have to converse about what he wanted, given that he had met with a realtor, and that would have given the impression that he wanted to sell the house.
Your Honor, none of that foundation has been laid out, and she's asking directly, what would the defendant want in his own state of mind? That is speculation.
I'll shortcut this a little bit. I'm going to sustain the objection in part. I think as a realtor, she can explain what she understood he wanted her to do, and she can't read his mind. What he said, what did you understand you were asked to do?
Miss Davis, when did you first meet Dusty Lawrence?
I first met Dusty in April of 2022, right after his great-grandmother passed away and left a house to them. I later learned that this house was known as the Castlin House.
And what did Dusty want to do with the Castlin House?
Well, through our discussions, I learned that Dusty was wanting to sell the Castlin House because it was too much for him to handle. It's not uncommon for a client to inherit a home to want to sell it once the probate ends, so I agreed to tour it.
How did these tours go?
Well, there was nothing inherently wrong with the house. There was some out-of-date carpet and wallpaper. The biggest setback was the lack of driveway, but despite that, it was a beautiful home with a gorgeous library.
so of course I agreed to list it.
What did you list the property for?
Well, after a lot of discussion, Dusty and I decided to list the home for $1 million, and we signed a 6-month contract where I would receive 6% commission.
Did you get any offers during this period?
Yes, we did. During the 6-month period, we received 6 or 7 offers ranging from $400,000 to $500,000.
What was Mr. Lawrence's response to these offers?
Well, Dusty and I decided not to accept any of these offers.
And what happened once this 6-month contract was up?
Well, we actually ended up going the whole 6 months without selling the property. So Dusty decided that he wanted to start doing some renovations in hopes of getting a higher sale price.
And how did these renovations impact your listing?
Well, he decided not to relist with me immediately, but he did express that he would be willing to in the future, and I really appreciated that. So I told him that if anyone reached out to me in the meantime, I would only take 4% commission if one of them led to an acceptable offer.
Did Dusty agree to these terms?
Yes, so I also gave him a little bit of advice to help keep the value of the property up in the renovations.
What was the advice that you gave him?
I told Dusty that if money were to become an
Your Honor,
issue,
hearsay.
That's what she told Dusty.
Yes, Your Honor.
Your Honor, this is an exception to hearsay under Rule 803, that an existing state of mind. This goes to show an intent and plan with the witness to re-up and plan out this new advice that they give them, so I believe that this is not hearsay.
Your Honor, this is still a out-of-court statement being used to prove the truth of the matter asserted. This is not showing to the witness the state of mind, but rather the truth of the matter asserted through her own statements.
What is the truth of the matter asserted?
That this plan was beyond what she told us upon what to do. That is a out-of-court statement.
I appreciate the arguments. I'm going to let her explain it since we've gotten into that area.
Yes, Your Honor.
Were you finished with your response?
no, I wasn't. I told Dusty that if money were to become an issue for him, that he should make sure that he maintains the insurance and the landscaping. And then the first to go would have to be the security systems.
Did Dusty agree to this?
Yes, he did.
Now, over the renovation period, were you ever approached by someone interested in the Castle House?
I was. On February 12th, 2023, I was approached by a developer who was interested in the Castle House.
What was their offer?
$700,000.
What did you do once you had this large offer?
I immediately called Dusty and I wanted to schedule a time to meet with him.
Did Dusty agree to meet?
Yes, he did. Whenever we were on the phone, I let him know that this was our highest offer yet.
And what did you discuss with this meeting time? When did this occur?
Well, we planned to meet on February 14th at 5:30 p.m.
And did you end up meeting with Dusty on February 14th at 5:30 p.m.?
Not exactly. Dusty didn't arrive by 5:30, so I called him to see where he was at.
What did Dusty say?
Well, Dusty was very apologetic and just informed me that he was in the process of switching from the night to the day shift and laid down for a quick nap and slept through his alarm. I was annoyed at first, but he did arrive only 10 minutes later.
Your Honor, at this time, I'll be referring to Elizabeth, previously marked as Exhibit 10. Let the record reflect, I am showing a copy to opposing counsel. And first witness. Ms. Davis, what is this document I just handed to you?
This is a written offer for $700,000. I showed this to Dusty at our meeting and I explained to him our situation.
Is this a fair and accurate copy?
It is.
Your Honor, at this time, I move this document to be entered into evidence as Defense Exhibit 10.
No objection, Your Honor.
May I punish the jury? Ms. Davis, what did you explain to Dusty based off this document?
I explained that accepting this offer meant that Dusty could stop with the renovations and he would be guaranteed the money rather than holding out hope for a higher sale price. I also stressed that a higher sale price than $700,000 would be no means guaranteed.
What was Dusty's response to this?
Dusty's face lit up. It was the first time I'd seen him respond positively to an offer.
Did Dusty accept the offer?
Not right away. He said that he wanted some time to think it over and talk to his cousin, Mickey Logan.
Ms. Davis, when Dusty left the meeting, how did you feel about this offer?
I was beyond excited. I thought that this would finally be my opportunity to sell the Castleman house.
Thank you, Your Honor. I have no further questions at this time.
Cross-examination.
Yes, Your Honor. Good morning, Ms. Davis. I want to talk to you about the $700,000 offer. This offer came to February 12th, correct?
Yes, it did.
Just so we're clear, that is 2 days before the fire.
Yes, that is correct.
And when you received this offer, you went ahead and called Dusty to let him know an offer had been made on the house.
Yes, I was so excited to let Dusty know about this offer since it was our highest
And
yet.
then you two arranged a meeting on February 14th, the afternoon of.
Yes, we did. We scheduled a meet at my office at 5:30 p.m.
And during this call, you never told Dusty how much his offer was.
No, but I did let him know that it was our highest offer yet.
And Dusty never asked how much that offer was.
No, Dusty was just very intrigued with what I was saying since it was such a high offer.
Dusty never asked who was making this offer.
No, it didn't seem relevant at the time. We were going to talk about that at our meeting.
I'm not asking about what you're going to talk about at the meeting. I'm asking you what you were talking about now during this call. He never asked any more details about this offer, did he?
No, it wasn't necessary for him to.
And I'll talk to you about a few weeks before the fire. He came to you and asked you how to apply for a home renovation loan, right?
Yes, he did.
Just so we're clear for the jury, a home renovation loan is when someone needs money to continue renovations on a house, right?
Yes, that is correct. A lot of people do that when they're renovating a home.
And at this point, Dusty needed money, didn't he?
Yes, he did.
I'll talk to you about the day of the fire. Dusty arrived late to your meeting.
Yes, only by around 10 minutes.
He also appeared agitated when he arrived.
Yes, slightly, but I assumed that was just because he had just woken up and he was late to our meeting. And
He also smelled of chemicals when he arrived.
he did, or at least I thought he did. I had a really bad case of COVID-19 back in
I'm not asking
2020,
about
and
COVID. Dusty smelled of chemicals when he arrived. Yes or no?
yes, but as I was trying to say, I
Ma'am,
sometimes have
ma'am,
phantom smells.
yes
Objection,
or no?
Your Honor. Badgering my witness is trying to respond to his questions and he keeps interrupting her statements.
I will allow him to ask for a yes or no question. You may throw this up on redirect. Go ahead.
Yes, Your Honor. Now from there, the defendant told you he had recently lost his job.
Yes, he did let me know.
Now this is the first time you've ever heard about that.
Yes, but I don't talk to Dusty frequently, only about our business.
And you also learned he had recently been turned down for that home renovation loan you guys talked about previously.
Yes, I did, but I suspected that would happen.
Now this concerns you because he still had monthly payments on his house such as landscaping, utility, and other costs, right?
Slightly, but I wasn't too concerned since we did have such a large offer on the table.
And you would agree Dusty was having some financial problems.
Yes, somewhat.
And despite these financial problems, Dusty had still yet to ask you how much the offer was on the house.
Yes, we were just catching up a little bit before we started our official meeting.
Thank you, Your Honor. No further questions at this time.
Redirect.
No, Your Honor.
Mike, witness is excused. And your next witness.
Yes, Your Honor. At this time, the defense calls Dusty Lawrence.
Dusty Lawrence.
Please introduce yourself to the members of the jury.
My name is Dusty Lawrence. I live right here in Scarborough.
Why did you decide to testify today?
There's been some talk that I'm something of an arsonist, which is rather crazy, really. I'm here to take the blame off my shoulders and say that I did not burn down my great-grandmother's house.
How did you come to own your great-grandmother's house?
Nana passed away around Easter of 2022. Now, I was shocked when I heard I inherited her house, even though I was her only great-grandchild. She called it the Castleman House, and I'm a sucker for a home with a fancy little name.
Why did she call it that?
There was a story she used to tell me about it, something about the founders of Castleman County having relatives who actually built the house. I really miss Nana and all of her stories.
Mr. Lawrence, did you ever plan on living in the home?
No. I loved the house, and I loved all the stories that went with it, but it was just too much house and too much upkeep. I mean, what's a man to do with all that square footage? I decided to talk to a realtor about selling.
Who was the real estate agent that you met with?
Shay Davis. We decided to set up a meeting after the house went through probate and was officially in my name.
Now, did you learn anything about the home during this probate period?
I did. I learned that it was assessed at $1 million, but that it was also very costly to upkeep. We're talking about hundreds of dollars a month in security, landscaping, and utilities. I also learned that I needed an insurance policy.
Now, were you ever able to actually meet with Shay Davis?
Yes, we set up a meeting in May of 2022, and we decided to set the house on the market for 6 months.
And did you get any offers during this time?
Yes, but the highest was for $500,000. We decided to set the house on the market for $1 million, and I didn't really know why we weren't getting the $1 million. But that just shows you how little I know about selling a house. I decided not to relist with Shay after the 6 months.
So what did you do next?
Well, I had been watching some Flip or Flop on the HGTV channel, and I had a light bulb moment. I could sell the house for $1 million by doing some renovations.
Did you have anyone in mind to help out with this?
I did. My cousin Mickey Logan owns Kentucky they own a renovation company. That's what's important. I decided to talk to them about helping me renovate.
And did Mickey agree to help you out?
Yes. We set up a plan where I would take care of half of the supplies and utilities.
What kind of renovations were you going to do on the home?
Mainly cosmetic work. You know, updating the kitchens, the bathrooms, adding some off-street parking. Mickey thought we could get it closer to that $1 million mark with those renovations.
Objection, Your Honor, to speculation on what Mickey Logan thought. This witness is going directly into the mind of Mickey Logan, and this is simply not allowed.
May I respond, Your Honor? The defendant in today's case has had multiple conversations with Mickey Logan. The reason that Mickey was even asked to help renovate the home in the first place was to hopefully bring a higher sale price, so I do believe that the defendant has the knowledge to know why they were renovating the home.
Your Honor, if I may, this is still going into the mind of Mickey Logan, and that is speculation.
Well, although that witness has testified, the jury will be able to determine this part, and I'm just going to sustain the objection. We'll move on.
Yes, Your Honor.
How were the renovations going for you?
Slow. I thought they would all go a lot faster, but that just shows you how little I know about renovating a house. I was putting a lot more money into the house than I was getting out.
What do you mean by that?
Well, the off-street parking I mentioned earlier, that wasn't even going to get finished until spring. I was putting so much more money into it than I was getting out.
Now, did you do anything to help your financial situation?
I did. I talked to Shay Davis about what I could do, and it was mentioned I could cancel the security system. I also offered to help out with the renovations, just to make everything go by a little faster.
So what kind of renovations did you help with?
Really odd and end stuff. You know, stripping wallpaper, going to pick up supplies. I specifically remember going to pick up some linseed oil-based stain to stain the library at Full House Hardware.
And when was this?
This was about a week before the fire, February 7th. Jody Calloway was actually working the counter that day.
Now, did you end up actually staining the library with this linseed stain?
Yes. We stained the library on February 14th. Mickey and I worked all day. He left at around 4:30, but I stayed until 5.
Dusty, did you know the linseed oil stained rags were flammable?
Yes and no. I mean, there was a technical sheet that was given, but I didn't really read it too closely. I mean, Mickey was the contractor after all, not me. I skimmed it.
Did Mickey give you any special instructions on how to dispose of the rags?
I was told how to be careful with the rags, but not how to be careful with them. I didn't know if they meant not letting the stain get on anything else, or really what they meant. They also told me to read the sheet.
What did Mickey do with the rags whenever they left that night?
He just left them there for me to deal with.
So what did you do with the rags?
I pushed them in a little pile near the library door. I thought it was just tidying things up.
What time did you leave the home that night?
I left the house at 5 o'clock. I had a meeting with Shay Davis at 5:30 and wanted to go home to wash up and take a little nap.
Did you make it to the meeting on time?
Unfortunately, no. I overslept. You never know how tired renovating a house makes you until you renovate a house. I made it to the meeting at around 5:45.
Now, what was this meeting for?
Shay had called me a few days before saying that there was a big offer on the house and that it was our highest offer yet. And I wouldn't even need to finish the renovations or anything.
Well, how much was the offer for?
$700,000. That really was our highest offer yet.
Did you accept it?
No, I wanted to, but I decided it would be best to talk to Mickey about it first. Of course, none of that mattered as my Nana's house went up in flames.
Thank you, Your Honor. No further questions.
Yes, Your Honor. Mr. Lawrence, you're a convicted felon, aren't you?
Unfortunately, yes. I made some bad decisions in my past.
You were convicted of the felony embezzlement.
Yes, unfortunately.
I want to talk to you about your finances right before the fire. About a month or so before the fire, you had no source of income after being laid off.
That is correct, yes. It was an unfortunate time for me.
2 weeks before the fire, a bank denied you a home renovation loan.
That is correct, yes.
Tell the jury just how much you asked that bank to loan you.
$30,000. It was a renovation loan that would help pay for some of the renovation costs.
$30,000. You needed a lot of money, didn't you, Mr. Lawrence?
I did. Renovating a house was costly, and I didn't really know all of that before going into this.
The reason you needed all this money is because without a job, your finances were dwindling.
They were. I was running a little low, but I was hoping we could sell it faster, and that's why I applied for the loan.
Putting costs of renovations aside, I'm talking about expenses like utilities and insurance at the Castle House. You were paying well over $1,000 each month, weren't you?
Yes, it was very costly.
While these financial pressures were growing, you decided to cancel the security system at the Castle House.
Yes, I took up some advice, and in retrospect, it was probably the bad advice. The only thing I'm guilty of is following bad advice, not of setting an arson.
Mr. Lawrence, just so we're clear, that security system included a smoke alarm linked to 911.
That is my understanding, yes.
Canceling would cancel that smoke alarm system.
Yes.
And firefighters would no longer be immediately notified in case of a fire.
That is my understanding.
Let's see if canceling the security system was even worth it. Tell the jury just how much you saved each month by canceling the security system.
It was $50, and over a long period of time, it would save more.
So out of all that money you're paying, you're only saving $50 each month.
Yes, but every penny helps.
Let's see if this was really about cutting costs. The fire to the house happened in February, correct?
That is correct.
Your Honor, may I approach Retrieve Exhibit 1, the photocopy of the house? Now, Mr. Lawrence, I'm looking at this, and maybe I'm just not seeing it. But the grass here in this photo, it's not any type of special grass, is it?
I don't think so. I'm not a landscaper, but it looked like pretty grassy grass.
The reason I ask, and tell me if I got this right, you canceled the $50 smoke alarm, yet you were still paying $250 for landscaping in the middle of winter when grass in Kentucky doesn't grow.
Yes, but you have to understand, we were trying to sell a house. I wanted the appearances to be top-notch.
Mr. Lawrence, that was not my question. Yes or no, you canceled the $50 smoke alarm, but you were still paying $250 for landscaping.
Yes, I was.
Let's talk about the effect a fire could have on you financially. You had $1 million insurance policy, correct?
I did.
And you thought you would get all that money if something like a fire destroyed the house.
I mean, that's why I was in place. If anything happened, I was hoping to get the compensation.
And you knew the insurance would only pay if the fire was accidental.
Yes.
The insurance would not pay if the fire was determined to be intentional.
That's correct, and it wasn't set intentionally.
On direct examination, you were being asked about an offer you received. Let's talk about that offer. When your realtor called you 2 days before the fire to inform you of this offer, she did not tell you how much it was for.
No, but she told me it was our highest offer yet, and I wouldn't even need to finish renovations. That sounded pretty good to me.
The first time you heard the offer was for $700,000 is while you were standing in her office while the Castle House was burning down.
That was the first time, yes.
So this means that while you were by yourself, alone, in the Castle House with those linseed oil soaked rags, At that moment, you did not know how much that offer was for, did you?
I didn't. I knew it was for the highest offer yet, and I wouldn't have set a house on fire if I knew that there was a
Mr.
large
Lawrence,
amount
that
of
was not
money
my
involved.
question. My question was, at that moment, when you were staining the library floor, you did not know that offer was for $700,000, yes or no?
No.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. Mr. Lawrence, why did you cancel the home security system?
I took some advice from my realtor, Shay Davis. She recommended that I cancel the security system if I was having financial trouble.
Thank you, Your Honor. No further questions.
Can you recross?
No, Your Honor.
All right, thank you. Witnesses.
May I return Exhibit 1 back to the bench?
All right, this now concludes the case in chief of the defense. Again, would the parties like to take a brief recess before the closing arguments?
Yes, Your Honor.
Yes, Your
All right,
Honor.
we will have a 5-minute recess. Anybody else? All right, thank you for being so prompt. We're ahead of the 5 minutes allowed. As soon as everybody gets seated and situated. Everybody ready? And both sides have rested their case. And this year, we're doing this a little differently. I am actually going to read the jury instructions into the record to the jurors, which would typically be done in an actual trial to frame what the closing argument should be about. So at this time, I'll read the instructions. Instruction number 1 in the case of Commonwealth of Kentucky versus Dusty Lawrence. Instruction number 1 is unanimous verdict. The verdict of the jury must be unanimous and signed by one of you as foreperson. You may use the verdict form provided at the end of these instructions in writing your verdict. Instruction number 2, presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against the defendant. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that the defendant is guilty, you shall find him not guilty. Instruction number 3, definitions. Building, in addition to its ordinary meaning, specifically includes any dwelling, hotel, commercial structure, automobile, truck, watercraft, aircraft, trailer, sleeping car, or other structure or vehicle, or any structure with a valid certificate of occupancy. Intentionally. A person acts intentionally with respect to a result or to conduct when his or her conscious objective is to cause that result or to engage in that conduct. Instruction number 4, second-degree arson. You will find the defendant guilty of second-degree arson under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county, on or about February 14, 2023, before the finding of the indictment herein, the defendant destroyed or damaged a building located at 754 Elm Street by fire. B, that the defendant started the fire intentionally. C, that in so doing, it was the defendant's intention to damage or destroy the building. And D, that the defendant's purpose in doing so was to collect insurance proceeds for such loss. The winner today will be announced by a return of verdict, and the verdict forms are form verdict A, we the jury find the defendant Dusty Lawrence guilty under instruction number 4 of arson in the second degree, a place for the foreperson of the jurors to sign. Or we the jury find the defendant not guilty under instruction number 4 of arson in the second degree, and a place for the foreperson to sign if that is the option chosen. Are counsel ready to proceed with their closing arguments?
Yes, Your Honor. Before I begin,
Yes.
I'd like to reserve any remaining time for rebuttal.
Certainly.
Also, before I begin, I just want to make the court aware that both parties are permitted to reference the jury instructions in closing arguments.
Thank you. You may begin.
May it please the court, opposing counsel, members of the jury. Remember when my co-counsel started this trial by getting up here and knocking papers to the ground and saying, whoops, that was an accident. And you, the jury, immediately thought, no, that was accidentally on purpose. That's because every action before then showed that it was intentional. That's exactly what we saw here today. Whoops, spontaneous combustion. No one believes that for a moment. Members of the jury, look at everything that happened before the fire. The defendant was out of money. He was denied a bank loan and he disabled the smoke alarms. That's why when the defendant says, whoops, that was an accident, the only proper response is no. You did that on purpose and you are guilty of arson. These are the jury instructions that Judge Easton has already read to you. Let me review the most important parts. You will find the defendant guilty of second-degree arson if you believe that on or about February 14th, 2023, the defendant destroyed or damaged a property located on 754 Elm Street by fire. That the defendant did so intentionally. And that the defendant's purpose in doing so is to collect the insurance proceeds for such a loss. Our witnesses told you everything you need to know. Detective Oldham was our first witness today. She told you how the defendant disabled the smoke alarm right before the Castle House fire. That act is not a coincidence. That is the act of someone who does not want to be caught. Then you heard from the neighbor, Jody Calloway, who told you that as she watched the Castle House burn, the defendant was on the phone asking, how do I get that insurance money? That is not the behavior of an innocent person. Then you heard from the contractor, Mickey Logan, who left the defendant alone in the house. He told you that as the fire burned, the defendant bragged of how insurance money was going to take care of all of these problems. I'll say it again. That is not the behavior of an innocent person. As the Commonwealth, we have the burden of proof. To prove beyond a reasonable doubt that the defendant intentionally set fire to the Castle House. We accept that without hesitation. Because the evidence goes to prove only one conclusion. This was not an accident. This was arson. Think about the witnesses the defense called today. A real estate agent who only gave us one helpful piece of information. That the defendant showed up 10 to 15 minutes late to their meeting. Why is this helpful? Because across town, the Castle House was already burning. Then they brought to you an arson investigator who didn't even do an arson investigation. Didn't you find it odd how the investigator didn't interview any of the witnesses? Not even the defendant. This expert walked into the courtroom today and saw all of these people for the very first time. And then you heard from the defendant himself, who admitted that money was so tight he had to ask the bank for another $30,000 just to keep his head above water. Then he was denied. Then the smoke alarms were disabled, and then the Castle House was engulfed in flames. Now the rules we follow say the opposing counsel will come up here and try to explain away these financial problems and disabled smoke alarms. But I get a chance to come back and respond to what they say. And I'll explain to you why this case is not about spontaneous combustion, and why the defendant is guilty of arson. I'll be back in a few minutes. Thank you.
Thank you. And closing argument for the defense?
Yes, Your Honor. Your Honor, opposing counsel, ladies and gentlemen of the jury. Dusty didn't know. Dusty didn't know how hard it was to own a home. Dusty didn't know how difficult it was to sell a home. Dusty didn't understand the difference between assessed value and market value. Dusty didn't know how long and costly renovating the home would be. Dusty didn't know that Renewed Kentucky Home, the renovation company owned by Mickey Logan, was not going to do their job very well. Dusty didn't know the seriousness of what could happen if you don't dispose of linseed oil stained rags properly. Members of the jury, it is at this point I want to remind you the prosecution has the burden of proof in today's case. They must prove beyond a reasonable doubt that my client intentionally set a fire that destroyed the Castle home with the intent to collect insurance money. They have failed to meet that burden, and the failure lies in the doubts we have introduced in today's case. There's doubt in the investigation conducted by Detective Val Oldham. You learned today that shortly after the fire, Detective Oldham received a voicemail from Federal Ranch Insurance. So at this point, Oldham fell into confirmation bias. You heard from Holt Perry that confirmation bias is when an investigator comes to a conclusion early on in the investigation and then views everything from the lens of that conclusion already made. Less than 24 hours into this investigation, without interviewing anyone, without doing any research, Val Oldham already believed this fire was intentionally set. Confirmation bias 101 is what you've heard today. Not to mention the statements made by Jody Calloway that the prosecution wants you to believe. The things said by looking at the fire in real time and on the phone with 911 operators are completely different than the affidavit presented later. Now, you've heard a lot about red flags today from Val Oldham. However, Val Oldham and Cole Perry themselves both believe there is no magic number of red flags that determine a fire was intentionally set, and you heard from Cole Perry that context matters. Yes, furniture was moved out of the home. Logan suggested it. Yes, the security system was turned off. But he was just following the advice of their realtor. Yes, no one was home at the time of the fire. Nobody lived there. Yes, Dusty was struggling financially, but he could have sold the home for a massive profit multiple times because all that he had in his house were renovation costs. There's doubt in the motive presented today. Prosecution claims that Dusty burned down the home to collect insurance money, but members of the jury, you heard from Shay Davis, who told you Dusty was about to accept a $700,000 offer on the home. Prosecution wants you to believe Dusty had $700,000 sitting right in front of him and lit a match to it. There's doubt in the intentionality of the fire. You learned today that Dusty Lawrence and Mickey Logan were the ones staining the library on the day of the fire. Mickey Logan was the contractor. Mickey Logan was experienced with linseed oil stain, and quite frankly, Mickey Logan knew what Dusty didn't know. When Mickey left that night, he gathered their rags, placed them in a pile near the library door, and leave them for Dusty to deal with. They didn't get a container for Dusty. They didn't fill it with water for Dusty. They didn't even dispose of their own rags properly. But the prosecution wants you to believe that the average person should go above and beyond what the contractor they hired to do the work should do. When Dusty left that night, they gathered their rags, placed them in a pile near the library door, and left them, just like their contractor had done. If Mickey thought it was safe, why should Dusty think anything different? You heard from Cole Perry that as those rags were sitting in the pile, they were releasing heat into the chemical reaction taking place. So the rags at the center and bottom of the pile, that heat was trapped. It could not dissipate, eventually reaching ignition temperature. Spontaneous combustion, not an intentionally set fire. The prosecution has failed to meet their burden today because the doubt we have introduced makes it impossible for them to do so. It's because of that doubt, because of what Dusty didn't know, I ask you to find my client not guilty. Thank you.
Thank you, counsel. Rebuttal.
Yes, Your Honor. May I ask how much time I have remaining?
1 minute.
The defense is trying to make this case all about what Dusty didn't know. Let's go through what Dusty did know. He knew that he was running out of money. He knew that those linseed oil-soaked rags were dangerous, and he knew he would get $1 million if the Castle House burned. What he didn't know is how much that offer was for, why he was intentionally piling those linseed oil-soaked rags together in the Castle House. And one more thing, if this was really an accident, why did the defendant never just come out and say that? To the contractor, the neighbor, the police officer when being interviewed. Members of the jury, you are the first ones being told that this was an accident. Find him guilty of arson. Thank you.
Thank you, counsel. And that concludes the presentation of the case. Judges, I would please ask if you could complete those ballots as quickly as possible. You are, as a reminder, asked to score independently and not confer with the other judges as to any performance or otherwise. So have you all had sufficient time to consider your Star Award winners? We'll start with prosecution. Who are your Star Award winners?
We gave our star witness to Silas. And then star name to Caroline.
And now, defense, if you will present your star.
We gave our star attorney to Emma. Star witness to Claire.
All right, so there were 11 ballots. We calculated top attorney, top witness for the trial. Top attorney goes to prosecution Mia Duggan. Top witness goes to defense Silas Kugel.
Top attorney, top witness get a mention in next year's case, if you wish.
Yes.
Yeah. Okay. Do you want to sign the complaint or the answer?
We should have a trophy for loudest screamer. That would go to defense as well. All right. So of these 11 ballots, here's some fun stats. The highest point differential was by 8 points. The lowest point differential was a tie. The average point differential was 4 points. Very close round.
Everybody ready?
Yes.
I'm ready.
The verdict of the jury. We, the jury, find the defendant, Dusty Lawrence, guilty